Indiana has a moderately landlord-friendly lease termination framework that provides clear procedures without being overly burdensome. The governing law is found in Indiana Code, Title 32, Article 31, which covers landlord-tenant relations, along with the state's eviction procedures in Title 32, Article 30. If you manage rental property in Indiana, the process is straightforward, but there are specific requirements you need to follow to do it correctly. Let's start with no-cause termination. For month-to-month tenancies, Indiana requires either party to provide at least 30 days written notice before the end of the rental period. The notice must be delivered at least 30 days before the next rent due date. So if rent is due on the 1st and you want the tenancy to end on the last day of March, you need to deliver notice by March 1st at the latest. For fixed-term leases, the lease expires at the end of the agreed term without additional notice required, unless the lease itself specifies otherwise. If the tenant remains after the term expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement, subject to the 30-day notice requirement. Landlords who want to avoid automatic conversion should send written notice before the lease expires and stop accepting rent after the term ends. For week-to-week tenancies, Indiana requires 7 days' notice from either party, with the notice expiring at the end of a weekly rental period. For year-to-year tenancies, Indiana requires 3 months' notice, which is important for landlords who have annual leases that automatically renew. Missing the 3-month window means the lease renews for another full year. Now let's cover termination for cause. For non-payment of rent, Indiana requires the landlord to provide a 10-day notice to pay or quit before filing for eviction. Under Section 32-31-1-6, the landlord must deliver written notice giving the tenant 10 days to pay the full amount of rent owed. If the tenant pays within 10 days, the notice is void and the tenancy continues. If the tenant doesn't pay, the landlord can file an eviction action in small claims court or circuit court, depending on the amount and circumstances. Indiana's 10-day non-payment window is moderate, longer than the 3-day and 5-day states, but shorter than the 14-day states. The notice must clearly state the amount owed and the deadline for payment. Indiana courts expect the notice to be accurate. Overstating the amount owed or including disputed charges can create problems in court. Here's something important about Indiana's non-payment process. The state does not have a comprehensive statutory right of redemption that allows the tenant to pay at any point during the court proceedings and stop the eviction. Once the 10-day notice period expires and the landlord files for eviction, the case proceeds through the court. The judge has some discretion in how the case is handled, but there's no automatic right to cure by paying late once the case has been filed. This gives Indiana landlords more certainty in the eviction timeline compared to states with broad redemption rights. For lease violations other than non-payment, Indiana does not have a single detailed statutory cure period for most violations. The process depends on the terms of the lease and the nature of the violation. Indiana's landlord-tenant statute provides that a landlord can terminate the rental agreement for a material breach by the tenant, but it doesn't prescribe a specific 14-day or 30-day cure framework the way URLTA states typically do. In practice, the standard approach is to provide the tenant with written notice of the violation and a reasonable opportunity to cure before pursuing eviction. What constitutes reasonable depends on the nature and severity of the violation. For curable issues, like unauthorized occupants, pets, or noise complaints, providing at least a reasonable written notice period is expected. For violations that are more serious or that cannot be cured, like substantial property damage that has already occurred, the landlord can proceed more directly. Because Indiana's statute doesn't prescribe detailed cure periods, the lease agreement plays an outsized role in defining the termination process for violations. A well-drafted Indiana lease should clearly specify the grounds for termination, the notice requirements for different types of violations, whether the tenant gets an opportunity to cure, and the consequences of repeated violations. In a state where the statute provides broad strokes, The lease fills in the critical details. For serious violations, including criminal activity, drug-related offenses, and conduct that threatens health or safety, Indiana allows the landlord to pursue immediate termination. Under Indiana's criminal nuisance and drug-related property statutes, landlords can take action to remove tenants involved in illegal activity. The landlord provides notice of the violation and can file for eviction without waiting for an extended cure period when the circumstances involve serious criminal conduct. Indiana has a specific provision addressing situations where a tenant's criminal activity creates a nuisance. Under the Indiana nuisance statutes, a property where drug manufacturing, dealing, or other serious criminal activity occurs can be declared a common nuisance. This designation can affect the property itself, not just the tenant, so landlords have a strong incentive to act quickly when criminal activity is discovered. Removing the offending tenant is the first step in protecting the property from nuisance liability. The eviction process in Indiana goes through small claims court for most residential cases, though larger claims or more complex situations may be filed in circuit or superior court. The landlord files a complaint for possession after the applicable notice period has expired. The court issues a summons to the tenant and schedules a hearing, typically within 1 to 3 weeks of filing. Indiana's court process is generally efficient. At the hearing, the landlord presents evidence supporting the grounds for eviction, and the tenant has the opportunity to respond and raise defenses. Indiana courts allow tenants to raise defenses including improper notice, the landlord's failure to maintain habitable conditions, retaliatory eviction, and discrimination. If the tenant raises a valid habitability defense, the court may consider it when evaluating the eviction claim. If the court rules in the landlord's favor, a judgment for possession is entered. The tenant then has a specific period to vacate, typically determined by the court based on the circumstances. If the tenant doesn't leave voluntarily, the landlord can request a writ of possession, and the sheriff or constable carries out the physical eviction. The overall timeline from filing to removal is typically 3 to 5 weeks for uncontested cases. Indiana allows the landlord to seek damages in the same eviction proceeding, including unpaid rent, property damage, late fees, and attorney's fees if provided for in the lease. Combining these claims is efficient and avoids the need for separate proceedings. One aspect of Indiana law that landlords should understand is the state's approach to emergency evictions. Indiana allows landlords to seek emergency possession when a tenant's conduct creates an immediate and serious threat. The landlord can file an emergency petition, and the court can schedule a hearing on a shortened timeline, sometimes within days. This emergency procedure is reserved for genuinely dangerous situations and is not available for routine lease violations. Indiana also has specific rules about how the eviction process works in manufactured housing communities. The Manufactured Home Community Landlord-Tenant Act, found in Indiana Code Title 16, Article 41, Chapter 27, and Title 32, Article 31, Chapter 3, provides additional protections for tenants in mobile home parks, including longer notice periods and additional grounds for contesting termination. Landlords who operate manufactured housing communities need to follow these specific provisions rather than the general landlord-tenant statute. On the tenant side, Indiana provides several grounds for early termination. If the landlord fails to maintain the property in habitable condition, as we covered in our Indiana habitability video, the tenant can pursue remedies through the courts, including lease termination when conditions are seriously deficient. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Indiana has several military installations, including the Naval Surface Warfare Center at Crane, Camp Atterbury, and Grissom Air Reserve Base, making this provision relevant to military families in the state. Indiana provides early termination rights for victims of domestic violence, sexual assault, and stalking under Indiana Code Section 32-31-9. A tenant who is a victim can terminate the lease by providing written notice along with documentation, including a valid protective order or a police report documenting the domestic violence, sexual assault, or stalking. The tenant must provide at least 30 days' notice before the termination date. The landlord cannot charge early termination fees, and the tenant's liability is limited to rent through the termination date and any damages to the property. Indiana's domestic violence termination provision also includes a lock change right. The tenant can request that the landlord change the locks to exclude the perpetrator, and the landlord must comply. The cost of the lock change can be charged to the tenant unless the lease provides otherwise. Indiana also protects co-tenants when a domestic violence termination occurs. If the victim is on a lease with other tenants, the victim can terminate their portion of the lease without affecting the remaining tenant's rights and obligations. This prevents the victim's departure from creating housing instability for other innocent parties on the lease. Indiana strictly prohibits self-help evictions. Under Section 32-31-5-6, landlords cannot change locks, shut off utilities, remove doors or windows, remove the tenant's belongings, or take any action to force a tenant out without going through the court system. The statute provides that a tenant who is subjected to an illegal eviction can recover actual damages, attorney's fees, and court costs. Courts in Indiana enforce this prohibition, and landlords who engage in self-help face both financial liability and damage to their credibility in any subsequent proceedings. Indiana's anti-retaliation protections exist under Section 32-31-5-7. Landlords cannot take adverse action against a tenant in retaliation for making a good faith complaint about habitability to a government agency, exercising their legal rights under the landlord-tenant statute, or participating in a tenant's organization. If adverse action is taken within a reasonable time of the tenant's protected activity, the tenant can raise retaliation as a defense in eviction proceedings. One practical consideration for Indiana landlords: the state's larger cities each have their own local dynamics that can affect the termination process. Indianapolis, which operates under the consolidated city-county structure of Marion County, has the highest volume of eviction filings in the state and has implemented programs aimed at connecting tenants with resources before eviction proceedings advance. The Marion County Small Claims Courts handle a heavy caseload of eviction matters, and landlords should be prepared for potential scheduling delays during busy periods. Other Indiana cities, including Fort Wayne, Evansville, and South Bend, each have their own court practices and local customs that can affect how eviction cases are handled. Familiarity with the specific court where you'd file is an advantage when planning your termination strategy. Indiana requires landlords to return the security deposit within 45 days of the tenant vacating the property. The landlord must provide an itemized list of any deductions. If the landlord fails to return the deposit or provide the itemization within 45 days, they may be liable for the full amount of the deposit plus attorney's fees. Indiana does not cap the amount of the security deposit by statute, but market conditions effectively limit what landlords can charge. For the complete guide to Indiana lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.